is David Zocchetti. He's Chief Counsel and Director of Legislative Affairs at the California Emergency Management Agency. He served the agency for over 20 years in various legal, legislative, and programmatic capacities, and he's participated in over 30 federally declared and 60 state-declared disasters, including major earthquakes, hazardous materials spills, and wildland fires. He's a member of the National Urban Search and Rescue Legal Affairs Committee and the National Emergency Management Association Legal Counsels Committee. David earned bachelor's and master's degrees in environmental planning from the California State University at Sacramento and a Juris Doctorate from the University of Pacific's McGeorge School of Law. Dave?
Thank you, Jim, and good morning. Let's just set the stage here a little. Any lawyers in the audience? Okay, so for the next 25 minutes, think of hard questions to ask me. For the rest of you, I'm going to spend 25 minutes giving you basically a framework in order to have this discussion in terms of legal implications about the proposals and actual existence of alert and warning. I am not going to make you lawyers. As you probably know, and my slide kind of got ahead of me there, from the shark symbol there, lawyers are much maligned in the community. And to me, that's always kind of an interesting fact, and the fact that they use the shark as the symbol of the attorneys. And this gets into something that Dr. Maletti said about risk perception. And one of the things that I think is an interesting fact on that is since they've been recording shark attacks for many years, there's only been 60 deaths as a result of shark attacks. Whereas elephants, 250 deaths per year as a result of elephant attacks, which proves two things. One, Dr. Maletti's point about risk perception, and two, that elephants have much better lawyers than sharks. So as I said, I'm just going to give you a framework to discuss the legal issues and implications. The creativity of plaintiff lawyers is always surprising to me. So I am not going to be able to answer all of your questions or maybe even flesh out all of the issues in this discussion relative to legal issues and alert and warning. We will see those unfold as we move through this process of developing alert and warning systems and then see them in operation over time. Let me just ask a question. I know a lot of you represent governmental organizations. Have any of your governmental organizations, show of hands here, been sued? Yeah, of course. And I think that's kind of an important underlying message here. All the protections that I'm going to be talking about over the next few minutes are not going to prevent your organizations or from you being sued in your work capacities. That's just going to be a fact of life. As you probably realize, too, if you've thought about those lawsuits you have, very seldom are those suits successful. And I'm not talking about civil rights suits and then suits under contract and those type of things. But really, suits against governmental organizations, especially in this context that we're talking about of emergency situations, are very seldom successful. And as I mentioned, I'm going to give you some frameworks to have this discussion. So I'm going to hit on three areas. First area I'm going to hit on is authorization. Basically giving yourselves, what gives yourselves, your organization's authority to do something in this area of alert and warning. I'm going to talk about responsibility or accountability, how you might be held responsible, read lawsuit, for doing what you do in the area of alert and warning. And finally, I'm going to give you some tips on how to reduce your vulnerability, risk reduction, in terms of the possibility of those lawsuits that will inevitably be filed against you and your organizations from being successful. So that's essentially the framework that I'm going to work through with all of you. Now, first thing I'm going to talk about is this issue of authorization. To me, it's always kind of an interesting thing that one of the most common questions asked of my legal office is there any law out there that would prevent me from doing fill in the blank, such and such? Is there something, some court case, is there some statute that says I can't do whatever this person that's walked into my office is asking to do? Which from a governmental lawyer perspective is an interesting question. And I think it comes up a lot because in governmental law, the paradigm is kind of flipped over from what we deal with in our personal lives. Generally, particularly as Americans, we have this kind of general perception of the law in that we can pretty much do anything we want unless it's prohibited. either prohibited by some state, federal, or local law, or there's some moral or religious tenet that prevents us personally or our family from doing this certain thing. So our general perception as people functioning in the society is, so long as it's not prohibited, I can do it. Well, in governmental law, it's a different paradigm, as I mentioned. Really, it's an issue, do you have authority to do the thing you're talking about? And for example, like we're talking about today, alert and warning. And that authority comes in a couple different flavors. A lot of the authority our governmental agencies have is a general authority. You know, the highway departments have the general authority to provide transportation, be it highways or railways or whatever their particular mission is. They have this general authority to do something. And this is going to be important later on, too, when we talk about accountability. Or there's some sort of specific authority. And let's just give you an example in the area of alert and warning. As has been referenced already, California is embarking on the development of a high-speed rail system, basically running from Southern California to Northern California. And this is a multi-billion-dollar endeavor that's going to take probably many, many years to come into fruition. Well, the general authority there is to build a high-speed rail line. But somebody could come and ask me, well, does that include some sort of sensing system to determine if the Earth moves, that rail line should be shut down, or should that rail line, that sensing system, that rail line notify communities near the rail line about the seismic activity? Okay, well that's, okay, the general authority is to build a rail line, presumably a safe rail line for high-speed rail. The more specific authority would be something like, yes, thou shalt go forth and do a seismic monitoring to go into that railroad system. So when you're looking at governmental laws, a key thing to look at is your authority. Because really in governmental organizations, unless there is a statutory authority or through an appropriation process, basically the process that all governmental agencies, be at whatever level, get money, unless there's some appropriation of money for a particular function, you can't do that thing. You must have either a general or specific authority to make or undertake a particular transaction or activity or project in the governmental realm, much different than in our private lives. And one of the things I want to talk about here before I move off of authority is because one of the questions I get right after, is there a prohibition from doing the particular thing I want to do, is, well, if I don't have authority, who's gonna stop me? You know, who's going to hold me accountable? I mean, that's kind of the next question. And in some cases, no one. But in a lot of cases, there's going to be some constituency out there that's going to say, well, they spent money on alert and warning. I don't like that because I wanted this governmental agency to spend money on this other activity, this other project that I believe, from my particular perspective, is more important. And what that entity that feels that government shouldn't have done this particular project, like alert and warning, is they will bring a suit. They'll typically bring in a writ action against the governmental agency saying that was not an authorized activity. And that writ action will, if it goes through the courts and successful, will basically stop you from doing that particular action because there's only so much money to go around, which I think we acutely realize at the moment in governmental circles, that somebody will bring a court action. The other thing that could happen is the only group that's probably a little bit more maligned than attorneys are auditors. Most money, most funding that comes into governmental organizations is subject to audit. And there's a myriad of audit requirements. And when those audit processes come along, they will find if you were outside of your either general or specific authority to do what it is you plan to do, like alert and warning. And if you've ever dealt with governmental grants, which I know a lot of you have, they're generally very specific in what they're going to authorize you to do. So it's very easy for those auditors that come along later on to bayonet you after the war is over, to basically find that you have gone outside this general authority. Well, I know for a few of you, this is probably giving you Elvis flashbacks. But what I wanted to talk about here a little bit, kind of moving into this area of responsibility and accountability, again, read lawsuit, is the area, just give you a better sense of it, is this thing we've probably all heard about at some point in our educational careers or outside of that, is the thing called sovereign immunity. Comes from merry old England, where the king, the sovereign, could be found to do nothing wrong. Well, that seems kind of weird from an American context and for most other democracies. But this concept kind of carried over of the king can doing no wrong, because in the American context, we generally think of government by the people, or at least we think of government paid for by the people. So it made a lot of sense to have these general legal protections in terms of actions against the government, because if you are part of the government, the people, the taxpayers, if you sue the government and are successful, you're just really moving money from one pocket to the other. You paid in taxes, and now I'm suing to get my tax money back. So sovereign immunity was something very much institutionalized early on in our governmental structure. But over time, that has eroded. Most levels of government have waived their sovereign immunity to one degree or other. I think at this point, I know the federal government has to some extent. 31 states have waived all or part of their sovereign immunity from suit. Many local governments have also waived their sovereign immunity. But I think it's really important on this this basically consider the basis here is the presumption is governments are sovereign. They're not subject to suit. Your agency's starting point is not subject to suit. But as I mentioned, a number of states, a majority of states, and the federal government to some extent have waived their sovereign immunity. So they have given an opening basically for suits within a certain structure. And most governmental organizations, governments, have put together a scheme for how governmental organizations are sued. So again, contracting to our private life, like I did early on, it's pretty straightforward to sue someone in your private capacity. You just go file a complaint with the court and things move forward. In governmental circumstances, pretty much throughout the country, there's a very rigid statutory scheme for how you call presenting claims against the government. You have to go through a very specific process to get your claims even into the courthouse, and then you go through the normal civil process as you would as a private person. But all these schemes have been set up, making it much more difficult, at least, to sue the government. Now, what I wanted to talk about a little bit here, under this context of the king being dead, is specifically the most likely and most common way governmental organizations or governmental actors are sued is in what lawyers call torts, and particularly negligence. It's basically suits for injuries. And just to kind of give you this framework to start looking at these issues under the context of alert and warning, I mean, we all have heard a lot about tort suits. I mean, you just can't miss it if you watch TV and you hear about this reasonably prudent person standard, which we all argue, who the heck is that person? It's certainly not my next door neighbor. We all have those kind of discussions. But one of the things that's always left off in that discussion about the reasonably prudent person when you get sued is the second part of that. It's under like or similar circumstance. It's the reasonably prudent person standard under like or similar circumstances. So when these suits go to court, one of the filters that the courts use to judge these lawsuits is what were the circumstances? Are we under what's often called exigent circumstances? You're trying to get an alert out to the public under a short time frame during a stressful situation because you've had indication of Earth movement. Obviously, the court's going to take that into a different context than we're sitting here day to day making decisions as people in the governmental system. So it's very important to understand when these suits come against governmental organizations and in the context of alert and warning, they're going to take it in the context of what's going on. And then they're going to apply a framework, which I have just kind of illustrated up here. And and again, I think we have this presumption in our daily lives that we have some responsibility to help people or to do things, and that's really not true. And it kind of grates against us a little bit. And you hear a lot about Good Samaritan laws and things like that. But really, as individuals and as governmental organizations, unless you're required to do something, or you start to do something, you really have no duty to do something. So the first thing the courts are going to look at is you as an organization or your organizational representatives. Did you have a duty to do something? Did you have a responsibility to create an alert and warning system? And then part two, if there's no